The following is paid advertisement and does not reflect the opinions of this station. The choice of a lawyer is an important decision and should not be based solely on advertisements. The information presented in this program is general and is not intended to be legal advice and should not be relied upon or used without consulting a lawyer to consider your specific circumstances.
Questions about law, stories from the courtroom, cases that might impact your life. It's time for Tell Me I Have a Case with Dan Grimm and Matt Glenn from Cook, Barkat, Ponder, and Wolves. Find them at cbpw-law.com. Here's Dan Grimm and Matt Glenn.
And good morning and welcome back to Tell Me I Have a Case. I'm Matt Glenn alongside my partner Dan Grimm. It's the show where we invite you to take a second look at the world of personal injury litigation. You can find us on the web at www.cbpw-law.com or at 573-335-6651. Today we're going to talk about bad faith in insurance defense litigation of car accidents. And for that topic, Dan, we brought in a guest. Who do we have today?
Yes, we brought in Kip Robertson with Barnabas, Frickleton, Robertson, and Rader. Kip, why don't you tell the folks a little bit about yourself?
Sure. Well, first of all, Matt, Dan, thank you very much for having me on. It's a privilege to get to spend a few minutes with you this morning. Again, my name is Kip Robertson. The name of the firm is Barnabas, Frickleton, Robertson, and Rader. We're located in the Kansas City area, and we do work all over the state. And we focus in a lot of different areas: catastrophic personal injury, class actions, and high-stakes contract disputes, of which insurance bad faith cases sort of fall under that last category.
Perfect. And with what you do in your practice, you guys are located in Kansas City?
That's correct.
And what have you seen as far as with the civil jury trials since COVID? I know we've had some issues here with trying to get cases to trial because of COVID, and then the backlog post-COVID. Tell us a little bit about what you've seen on your side of the world.
Yeah, we're really having the same experiences here on our side of the state. COVID had a significant impact on just about everything, and the legal profession was no exception. So jury trials were basically stayed for a time, and they're now going again, but there's such a backlog of cases that we're having trouble sort of pushing cases through. And the criminal cases, of course, take priority due to the constitutional speedy trial requirement. And so civil cases are going, but there's a backlog, and we're hopeful that dam will break someday and kind of get back to normal.
Yeah, same here.
Yeah. Well, so we brought you on to talk about bad faith litigation, and that usually arises in the context of what we call insurance defense. I did insurance defense work for 13 years. I practiced in-house with an insurance company. What you need to know is if you ever get sued for a car accident, if someone alleges they were hurt and it's your fault, your insurance company is required to buy you an attorney. They're required to provide you a defense at no cost to you. They're also required to pay any judgment or settlement up to the limits of your insurance policy. They have a lot of rights that go along with that requirement. They have the right to control the litigation. They have the right to choose the attorney. And of course, they pay for that attorney. And I used to have a lot of people come to me in my office when I was defending them, and they'd say, they're asking for, an amount over $25,000. I'm only insured up to, say, $100,000. Are my personal assets at risk? And my answer to them was always, well, I can't say that they're not. Right? I can't tell you that it's 100% certain that your personal assets are not at risk. What I can tell you is that I've been hired to represent you. I don't represent the insurance company. I represent you. And I have never lost a dime of my client's own money. And it's my number one goal that when this case is over, I be able to tell my next client the exact same thing, that I've still never lost a dime of their money. And there are a lot of different ways that you can protect your clients as an insurance defense attorney. But there are times where the insurance company wants to take one course of action, and it's really in the best interest of the client to go in another course of action. And that's kind of when they need to get somebody like Kip involved. And so, Kip, is that kind of the scenario where an insurance company maybe doesn't want to settle a case, but it's really in the best interest of the client to settle it, or there's a reservation of rights? What are the sort of things that kind of lead somebody to your practice?
Yeah, so let me start with what you mentioned about the insurance company's right to control the litigation. Usually a liability insurance policy will give the insurer, the insurance company, the right to control the defense and the right to make the decision about whether a case should be settled and for how much. But with those rights come duties as well. And the law in Missouri is very clear that an insurance company has a duty to exercise what's called good faith in carrying out those rights it has contracted for in its insurance policy. And a lot of times insurance companies do the right thing, but when they don't, then problems can arise. And one of those areas is, as you mentioned, Matt, where that conflict kind of arises between the insurance company and the insured. And you referenced the settlement aspect of that. Sometimes it's in the client's best interest to have the case settled for the amount within the policy limit. And inherently, there's this tension between the insurance company and the insured, because the insurance company wants to settle the case for the least amount of money possible, typically. That's not always possible. And so when the insurance company puts its interests ahead of its insured, in other words, it has an opportunity to settle the case on its insured's behalf and take away that possibility of a judgment that exceeds the policy limits, and it doesn't do that, then that can give rise to a scenario called bad faith failure to settle. And if the case goes on and gets tried to a jury and there's an excess verdict and judgment entered where the amount that the insured is told they have to pay is more than the insurance policy limits, then they potentially have a remedy against the insurance company. So that's the bad faith failure to settle aspect of things. And you also mentioned a reservation of rights. And that is a letter that can be sent by an insurance company to the insured, basically saying, we are going to continue to defend you in this case, but we are going to do so subject to our right to later come back and change our mind and say, we're going to now deny coverage. That puts the insured in a very difficult scenario, and insureds have options under Missouri law when that happens.
Yeah, and so to unpack that a little bit, in terms of a failure to settle, that typically happens when somebody has an injury, and let's say they require a neck surgery that cost $150,000, and there's only $100,000 worth of coverage. The insurance company doesn't have the right to simply say, well, we only have $100,000 worth of coverage. We'll just try this case, and the most we ever have to pay is $100,000. If they're given the opportunity to settle, they're required to take that opportunity. Have I summed that up?
Right. That's right. That's part of that duty of good faith. And, insurance companies in Missouri have what's called a fiduciary duty to their insureds. And what that means is they have to put their insured's interest ahead of their own. So if they have an opportunity in your example, Matt, to get that insured out for $100,000 in a case where the damages are clearly much more than that, then the duty of good faith would require them to accept that offer and protect their insured. That's what the premium was paid for the insurance.
Yeah, that's what that insured bought. When he paid his monthly premium every month, that's what they're purchasing.
Exactly.
And just the fiduciary duty, if they have a fiduciary duty, how do you see situations arise where they're in bad faith? I mean, have you seen what kind of situations arise where they didn't follow through on their fiduciary duty?
Yeah, so I've had a number of cases, just like the example that Matt described, where you have a policy limit that is lower than the damages that were sustained by the injured party. And, when the insurance company tries to save a couple of bucks off their policy limit and they blow an opportunity to settle the case, then that puts the insured in a bad position because they may now have to go through a trial, and there's the risk that there's going to be a very large judgment that exceeds the policy limits. And so that happens occasionally. And the other scenario where it happens is really before you ever get to the part where you're talking about settling the case. Sometimes insurance companies will just deny coverage at the outset. And sometimes they have a good policy defense that means they don't have to provide any coverage. But, occasionally they're wrong about that. And, when that happens, that gives rise to a breach of contract action that can be called bad faith refusal to defend. And so I see that fairly regularly, where an insurance company is obligated to exercise those duties to defend and settle, on behalf of one of its insureds, and they just throw their hands up at the beginning and say, we're not going to cover you. You're on your own. And that puts the insured in a really bad position. And often insureds don't know what to do. And that's really the point at which they need to contact the lawyer.
Absolutely. Yeah. When you see somebody who is being threatened with a lawsuit and their insurance company is not even going to provide them with an attorney, that's when they really need to contact our office or your office and say, hey, I'm under this threat here. and my insurance company is saying that they're not going to cover me. That's kind of an all or nothing decision made by the insurance company with a lot of really high stakes, because it puts the defendant in a really tough spot. But the good news for them is that somebody like you, Kip, can give them some options.
Right. And there are some options under Missouri law. And I would also mention very briefly, Matt, that, other scenarios where an insured may want to contact a lawyer is if they receive a reservation of rights letter. That's very important to contact a lawyer if you receive one of those. And then also, if you're in a scenario where you want the case settled, but the insurance company is refusing to settle the case, a lawyer can potentially help you get that done. And then if it's not done, again, there are those remedies. But some of the things that can be done under Missouri law is there's a statute called 537.065, which allows an insured whose insurance company has denied coverage to them basically to enter into a contract with the injured party, the purpose of which is to protect the insured's personal assets. And so that's one mechanism that our legislature has put into place to protect insureds whose insurance companies don't do the right thing. And that's the type of thing you need legal advice for in order to get that contract entered and then help the insured at that point sort of comply and follow through on the terms of that contract.
Yeah, and you want to get that legal advice from somebody who's not being paid by the insurance company. You want to get somebody who doesn't have any sort of relationship, financial responsibility to the insurance company. And honestly, you can come to someone like Kip's office or our office, and you come to us, we're probably going to send you to Kip. But that you can write what's known as a kind of a hammer letter, which says to the insurance company, hey, you've got an opportunity here to do right by your insured. You need to do that. Or he will assert his rights.
Right. And a lot of times hammer letters are effective. And Matt, you're exactly right. It's important that you have an independent lawyer who does not also have loyalties to the insurance company. And so the term that we use in the legal community is a personal counsel. That's somebody who is your lawyer and your lawyer only. They are not beholden at all to the insurance company. The insurance company is not paying them to represent you. Their job is to make sure that you, the insured, are being protected.
Yeah, I think a lot of people don't realize what the potential conflict where when they have an insurance company attorney represent them versus their own personal counsel. I think a lot of people think, well, this is what I pay for. They don't realize the inherent conflicts that may take place.
Yeah, there are some inherent conflicts there. I mean, the insurance company is paying the bill of the lawyer who they hire to represent the insured. Now, I think as Matt said earlier, lawyers who are hired by insurance companies to represent insureds are required to put the insured's interest first. The insured is their client, but still there's that sort of underlying, almost subterranean type conflict that sort of infects the entire relationship. And that's why it's important to have an independent lawyer when things start to go sideways with the insurance company.
Right. We've been talking with Kip Robertson. He's at Bartimus, Frickleton, Robertson, and what's that last word? Rader. I'm sorry. He's at Robertson, Frickleton, Robertson, and Rader. We'll be back for segment number 2. Don't go away.